In the early 1970s, there was great concern about attorney-client fee disputes clogging up the courts. And in 1978, the California legislature addressed that concern by passing Article 13 of the State Bar Act, which provides for a mandatory fee arbitration program between attorney and client when there's a dispute over fees or costs. My name's Joel Mark, and I've been practicing business litigation for 42 years. And for 15 of those years, I have been a member of the State Bar Standing Committee on Mandatory Fee Arbitration. And for 4 years, I have been the State Bar's presiding fee arbitrator. The program is mandatory, as the name implies. And any attorney who has a fee dispute before or at the time they file a lawsuit against a client has to give the client written notice of the client's right to elect to send the dispute to mandatory fee arbitration. The mandatory fee arbitration program is operated by the State Bar Fee Arbitration Committee, but 90% of all the fee arbitrations are actually handled by local bar programs. And in fact, there is no State Bar jurisdiction unless there is no local bar program. So most of the arbitrations will take place in the community where you practice. Some programs actually have a mandatory, a voluntary mediation program as well. What are the benefits of this program? Well, although people resist it, statistically, over 95% of all of the matters which go through mandatory fee arbitration, both the binding and the non-binding, end up as the final determination of the case, and it never gets back to court. That makes it a good deal. But the best way to handle a mandatory fee arbitration is not to get into a fee dispute to begin with. And the way you do that is by, first of all, having a written engagement letter with every single client you have. Go to the State Bar website and go to the mandatory fee arbitration page, and you will find a number of different sample fee agreements and clauses you can insert in your agreement, and start there and then tailor it to the individual representation which you're about to undertake. You then, after that, you manage the client relations and control your client expectations. You don't want to oversell the case. And you do that mostly by client communications. As my mentor once told me, if you keep their mailbox full, they won't be complaining that they didn't know what you were doing. And you do it also with your billing practices. Have bills that you send out on every matter where you're doing hourly billing. And my recommendation is always to cover those with cover letters which explain this is this part of the budget, this is what happened, this is what this bill relates to, was an unexpected experience and therefore the budget's going to be higher. Things like that keep the client informed. And then after a fee dispute arises, you want to be flexible with your client in terms of settling it. Even at your best effort at a fee dispute and the best outcome, you're going to have to earn that fee twice. So you might want to think about discounting what it is that's in dispute right from the get-go to avoid the agony of having to go through it, a fee dispute. If you get into the client opts for mandatory fee arbitration, you will go to a hearing, and it's an informal hearing where no rules of evidence apply, there is no discovery. Even if you have an attorney's fees clause in your agreement, you're not entitled to recover attorney's fees in that proceeding, because the theory is that the client shouldn't have to hire an attorney to deal with the first attorney that they're having a dispute with. So it's very consumer friendly in that sense, but our experience has been that at least the attorney comes out as successfully as the client does in these things, because the arbitrators go through training and they're very conscientious about it. There'll be one arbitrator unless there's a certain amount of dispute, in which case there'll be 3 arbitrators. In the case of a 3 arbitrator panel, one of the arbitrators has to be a non-attorney. And the non-attorneys, arbitrators, are also trained, and they are of great value to the proceedings. As I mentioned, there's binding and non-binding. All arbitrations that go through the mandatory fee program are non-binding unless after the dispute arises the parties agree to make it binding. But even if it's non-binding, if after the end of the award is rendered, nobody requests a trial in court within 30 days, the non-binding becomes binding. And as I said, most of them end up even the non-binding ones, with that conclusion to it. The arbitrators will conduct the proceeding in a way that tries to make it expeditious, usually by controlling the proceedings and making sure that the parties stick on message and are polite with one another and don't engage in time wasting and whatnot. Keep in mind, again, going back to the need for a written fee agreement, in many situations in practice in California, attorneys are required by the Business and Professions Code to have a written fee agreement. And if they don't have a written fee agreement, then they're not entitled to the contract fee. They're only entitled to the reasonable value of their services. And as much as you value the service you provide to the client, if you go to a reasonable value determination, the beauty of your legal work will be in the mind of some other beholder, an arbitrator or a three-arbitrator panel, in which case you might not get what you think the fee is worth or what the contract provided for. And that's why it's important for you to have that written fee agreement at the outset. Now, how to successfully survive a fee arbitration is pretty simple. Embrace the process. Remember, there's an over 90% chance it's going to be a satisfactory resolution. Embrace the process. Cooperate with the arbitrator and the scheduling and all the parties. Anticipate the claims and defenses and try and be as open about them as possible. Show respect for the client, because there's nothing that upsets an arbitrator more, or at least proves that maybe you didn't respect the client during the representation, is if you don't respect them during this proceeding. So you want to make sure you show respect for the client. You want to provide clear documentation of your services and their value. And that could be with the bills. That's the best place to start. But also if there's certain work product that's under question, you want to make sure that the arbitrators have not only copies of that work product, but explanations as to why it is that that work product was worth what was billed for it. And you want to make sure that you have provided the client with the file, because that is their right to have the file even without any kind of fee arbitration or any other kind of discovery whatsoever. Now, at the end of the hearing, there'll be an award. And if it becomes final, well, the award will specify who the responsible attorney is. And the reason that they do that is because there's an enforcement proceeding if a responsible attorney fails to pay an award that they're required to pay. And that is the State Bar's enforcement proceeding, where the State Bar presiding arbitrator can bring an action before the State Bar Court to have the attorney placed on involuntary temporary suspension from the practice of law until the award is paid. And that's a pretty powerful sanction. So that's why if you happen to have an award against you, you want to make sure you get it paid, and so you don't end up crosswise with the State Bar Court. So in conclusion, I just wanted to tell you that even though it seems like an obligation, embrace it, because it's really an opportunity. State Bar mandatory fee arbitration or local program mandatory fee arbitration is something that will really help you recover your fee in the most expeditious way. Thanks.